Twaomba uilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu. Uzalendo pia mshikamano viwe msingi wa umoja wetu, na tulinde uhuru na amani, mila zetu na desturi zetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu. Viwandani na hata mashambani, tufanye kazi sote kwa makini, tujitoe kwa hali na mali, tuijenge jumuiya bora. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Jambo na karibuni nyote kwenye kikao chetu alasiri hii. My name is Omolo Joseph. I am a lecturer at Kabarak University and also the head of Department, Public Law Department. We meet here today in this webinar that has been jointly organized with the East African Law Society to discuss a monumental development in the integration process within the East African community. On the 2nd of December 2022, the first instance of the East African community made its decision in a matter known as reference number 5 of 2020, that's Christopher Ayeko and another, versus the Attorney General of the Republic of Kenya and another. The subject matter before the court was the trade negotiations that have been ongoing between Kenya . Yes. Sorry, I dropped out. I'm back. So the matter that we are discussing today relates to the trade negotiations that have been going on between Kenya and USA, which had been challenged before the court at the beginning of 2020. In its judgment, the court made two fundamental findings. The first one was that Kenya, by entering into negotiations for a free trade area agreement and by adopting a memorandum of understanding on the certification of wheat grain with the US without involving other partner states, Kenya had acted in contravention of EAC law and that the outcomes of the negotiations were illegal, null, and void. Secondly, the court observed that by failing to take action against Kenya in relation to the above breaches, the Secretary General of the East African Community violated the EAC law. So today we convene here to have a discussion on this judgment and the impact that it would have within integration efforts in the EAC and Africa generally. We have put together a team of resource persons. We have in our midst the president of the East African Law Society, that's Honorable Justice Dr. Foz Twaib, who will be opening the session formally. The session will be moderated by Mr. John Nyanje, who is a doctoral research fellow at Multiple Cluster for Africa, University of Beirut and Leibniz University, Hanover. He'll be joining us in the course of the session. We have Professor Thomas Milej from Kenyatta University School of Law. We have Mr. Edmond Shikoli, lecturer, Kabarak Law School from Kenya. We have Mr. Emmanuel Sebijo from Uganda. He's Dean of Faculty of Law at the International University of East Africa. We have Ms. Jemima Muyama, who is an international trade law expert from Uganda. We have Ms. Molly Rigamba, who is the managing partner R&R Associates in Rwanda. You'll allow me to make brief remarks on behalf of the Dean School of Law, Kabarak University, after which I'll invite the president of the East African Law Society to formally open the event. Then we'll have the other sessions follow. As we all know, planning such events take a lot of effort. And in this regard, allow me to thank the East African Law Society team led by its President, Honorable Justice Dr. Foz Twaib, and the Chief Executive Officer, Mr. David Sigano. The Kabarak Law School team made up of the Dean, Professor John Osogo Ambani, Mr. Elisha Ongoya, Mr. Edmond Shikoli, Mr. Cyril Kubai, Mr. Jared Gikombe, Ms. Joy Marion, and Mr. George Gore. These persons have in various ways toiled in the past 2 weeks to ensure that this event is a success. And I know somebody in the audience might be wondering why I am thanking them this early. In reality, the most stressful day in the planning of big events as this is never really the D-Day. Once the D-Day arrives, then the event would usually take its own course and run whatever way it would, and the organizers can only hope for the best. So thank you very much for the sacrifice that you put into this. Those familiar with the history of integration within the EAC would know that one of the factors identified as a major contributor to failure of previous initiatives is the lack of participation by the private sector and the civil society in the integration process. Through this seminar that we are hosting together with the East African Law Society, we hope to make a small contribution in dealing with this problem. And we promise to continue doing so. Thank you very much to all our speakers who agreed to be part of this event. We do not take your support for granted. Having said that, allow me to conclude now by inviting the President of the East African Law Society, Honorable Justice Dr. Fawz Twaib, to also address you and officially welcome you to the webinar. Mr. President, welcome, and to everybody, merci beaucoup. Thank you.
Thank you very much, Joseph. I'm pleased to be here this afternoon. Ladies and gentlemen, good day to you all. On behalf of the Governing Council of the East Africa Law Society, and on my own behalf, I'm delighted to be presiding over this very important webinar. And this is one of my first activities in engaging directly with members since assuming office less than a month ago. Seeing collaborations such as this between the East Africa Law Society and the EALS Institute and the institutions of higher learning goes a long way to show the strides that the EALS is taking to help achieve the objectives captured in the Treaty of the establishment of the East African Community. Regional integration is part of our core mandate as EALS, as one of the few regional institutions with observer status in the East African Community. This we execute through support to formulation of policies, laws, fast-tracking the EAC integration process, and generally working towards borderless legal practice. Sensitization, active discussion, inclusion of students, working towards borderless legal practice, and the inclusion of academia as a whole are all building blocks that eventually lead to better and stronger cooperation within the community. To this end, I would like to extend my gratitude and congratulations to the organizing team of this event at the East Africa Law Society Secretariat, Kabarak University Law School, and all stakeholders involved in making this webinar. The establishment of a common market and a customs union is pertinent to the integration process of the EAC. Enjoying free movement of goods, services, and labor across borders, elimination of tariff and non-tariff barriers to trade, as well as having a common external staff, a tariff and non-tariff barriers to trade, as well as having common, are the hallmarks of these two stages of integration. The point of discussion revolves around two pillars of our integration as captured by the recent decision, which will be the subject of our discussion this afternoon, reference number 5 of 2020, which forms the basis of the deliberations, thoughts and questions around this particular topic. It is important to also point out some unique elements of this reference. The applicants in the matter are both lawyers and members of the East Africa Law Society. This stands out because of all the references brought to the EACJ so far. We are seeing a rising trend of advocates bringing matters to court, not only as counsel for their clients, but also as applicants and parties themselves, rightfully taking their place as key drivers in the integration process. The first time this was done was in 2011 by Mr. Samuel Mukira Mhochi. who had been denied entry into Uganda. Mr. Mohochi, you might be aware, has since been appointed a judge of the High Court of Kenya. In the present instance, we have two advocates who are not necessarily directly aggrieved in the matter, but have chosen to front this reference to the court in defense of the treaty establishing the EAC and its attendant protocols. And this is quite significant. It's a public interest process that must be emulated. It is significant because having lawyers acting as applicants in matters such as this assists the ELS in its function of promoting the mandate, the objectives, and principles of the EAC treaty, which includes adherence to the principles of rule of law. Active litigation by ELS members before the court is something worthy of praise, and we hope that we shall see more of this. The panel assembled by the organizers this afternoon consists of able and eminent speakers, and I'm sure that they will guide us through discussions of this very important topic. I wish once again to thank and congratulate the stakeholders, our strategic partners, Kabarak University Law School in particular, for making this possible, and to wish you all a wonderful time as we listen to the speakers and engage actively in the discussions. I thank you very much. Over to the moderator.
Thank you very much, Mr. President, for having officially opened our session today. At this point in time, now that we are done with the preliminaries, we want to shift to start handling the substantive sections of the webinar. And the first session will be taken by my colleague, Mr. Edmond Shikoli. Mr. Shikoli is an advocate of the High Court of Kenya and is also a lecturer at Kabarak University School of Law, where he teaches a number of courses, including East African Community Law. Mr. Shikoli luckily was one of the litigating advocates who acted for the applicants in reference number 5 of 2020 that we are discussing today. And Mr. Shikoli will provide to us the factual context of this case, given that this case has not been widely circulated, and I don't think it has actually been reported by the EACJ reporting mechanism as of now. So it'll give us the context that would help us through this session. Welcome, Mr. Shikoli.
Thank you so much, Joseph Agutu. I trust that you can hear me loud and clearly.
I confirm.
Once again, my name is Shikoli Edmond, teacher and practitioner of the law. As Joseph has pointed out, I was part of the team that represented the applicants in this matter at the East African Court of Justice. Mine is to give our audience a very brief background of this matter. As a person who has an interest in regional integration, it excites me every time I read an integrationist decision from the East African Court of Justice or any other international tribunal. I believe that this is our moment as the East African community and the regional court to try and participate in integration by the law. This reference has a foundation in the principles of our community that are provided for in Article 6 and 7 of the Treaty for the Establishment of the East African Community, 1999. This reference raises questions of fidelity to the law. It raises questions of the rule of law, accountability to written community rules. It raises questions of observance of the law. Most importantly, the principle of primacy of community law over partner states law, and of course, the processes that we have in the community for enforcing our rules. The dispute that the applicants took to court emanates from a transaction between the government of the Republic of Kenya and the United States of America. The applicants contended that the first respondent, who was the government of Kenya, and specifically on the 6th day of February 2020, without regard to various provisions of the treaty and its attendant protocols, the first respondent entered into negotiated and expressed intent to negotiate a bilateral free trade agreement with the government of the United States of America. So these negotiations led to the exchange of objectives, negotiation objectives, and of course, there was the adoption of a protocol or an MOU on the certification of wheat grain without involving the partner states in the community. So that was the major contention on the part of the applicants. But then on the part of the second respondent, that was the Secretary General of the community, the applicants argued that he failed to warn or stop the government of Kenya, who was the first respondent in the matter, from entering into the alleged illegal free trade agreement, and of course, adopting the phytosanitary documents. That was specifically a protocol whose effect was to, in fact, defeat the letter and spirit of the treaty. Now, as an advocate who represented the parties, what, in our view, was the effect of the said violations on our integration? We thought that the acts of the first and the second respondents in negotiating with a third party without involving the other partner states in itself jeopardized the adoption of a common East Africa community negotiation position between the community and a third party. But then how did the first respondent jeopardize the adoption of a common negotiation position? Simply, he did this by failing to notify the other partner states of the transaction. And of course, that denied the other partner states an opportunity to consider and comment on the free trade agreement in line with the dictates of the treaty and its attendant protocols. That was the background, or that's the background of the case that is subject of this webinar and the discussion that will ensue in the other sessions. Thank you so much. Over to you, Nyanje or Cheye.
Thank you very much, Mr. Shikoli. You make me so proud. And I must disclose that university, and he was one of my active participants in class in the East African community law. So I'm really happy to let me blow my own trumpet, having inspired you to also take this path. And thank you very much for that factual background to the case. With that, we will now want to shift to the presentation by Professor Thomas Mileja, who will essentially deal with the applicant's case before the court. And Professor Milej would look at the substance of the applicant's case. He'll look at the litigation strategies that were employed by the applicants. He'll also generally comment on what he thinks were the weaknesses or strengths of the applicant's case and any missed opportunities. And time allowing, he might also broaden the conversation to also talk about WTO jurisprudence in these regards. Professor Milej is an academician specializing in public international law, law of regional integration, and comparative constitutional law. He graduated from the European University Viadrina in Frankfurt with a degree in German law, and from the Adam, Professor Milej, you'll excuse me for not pronouncing some of these names properly.
Just leave it, Adam.
But from Adam University in Poznan with a degree in Polish law. He also holds a university diploma in European integration from the Jean Moulin University in Lyon. In 2006, he obtained a PhD at the University of Cologne, which was followed by a postdoctoral degree in the year 2014. In the year 2014, Professor Milej moved to East Africa and took up a position of DAD long-term lecturer at the University of Dar es Salaam. He joined Kenyatta University as a professor in the year 2016. And that's the job that he still carries out to date. In November 2022, he was awarded the Law Teacher of the Year award by the Nairobi branch of the Law Society of Kenya. And the same month, he was appointed the chairperson of the Department of Law at Kenyatta University School of Law. Welcome, Professor Milej.
Thank you very much, Joseph. Could you please confirm that I'm audible?
Yes, I can hear you very well, Professor Milej.
Wonderful. Thank you so much. So thank you for this kind introduction. Thank you also, Honorable Judge Twaib, for your kind words, and to Edmund for the excellent introduction to the background of the case. And above all, thank you, the organizers, for inviting me. I feel very honored by this invitation. So my job is to talk about the strengths and weaknesses of the applicant's case, not this judgment. And I can do so only while referring to the objectives which the applicants pursued and which the court pursued by handing down the judgment. And those objectives can be basically two. Yeah? So what can we expect from this judgment? We can expect that the court makes bold pronouncements of the objectives of the integration, that it develops the East African community law, that it sheds light on its principles, that it sheds light on the role of different EAC institutions. That will be the first objective, against which we can say that the case fulfills the expectations or not. The second objective, and I think it's even the more important one at the moment, is to avert the deal, is to stop Kenya from negotiating a bilateral trade deal with the US. And this judgment has its strengths, and the strength, or rather around, the strength of the judgment lies in the attaining of the second objective. Regarding the first objective, shedding light, developing of the law, my appetite as an academician is not fully sated. Leave it at that. I will give you just one example, or two examples. What the court could have said with regard to the failure of the Secretary General to intervene. The court basically said that the Secretary General was not diligent enough because in his coordinating role, because he wrote just one letter and did not follow up. Yeah, this is quite a bold statement, but okay, what are the systemic consequences of that? Yeah, every one of us who has ever dealt with a public institution knows basically that it is often, not always, but often, not enough just to write a letter and wait until the letter is being answered. What the court could have said would be to expound on the position of the Secretary General vis-a-vis the heads of states. For example, the Kenyan heads of state or the Ugandan heads of state. To answer the question, is the Secretary General, in the setting of the treaty, an agent of the heads of states? Does he report to the heads of state? Yeah? Or is the Secretary General an organ of the community on an equal footing with the heads of state? That is what the court could have said using this case. Is the Secretary General a guardian of the treaty? Is he a guardian of integration objectives, for example, such as development of common external trade policy? This is an objective explicitly envisaged in the Customs Union Protocol. Is it an organ, an institution, watching over the interests of the community taken as a whole, rather than the sectarian interests of the partner states, which the heads of states sometimes, national governments sometimes prioritize? So that could have been a statement which would develop the community. Another example of a bold pronouncement which the court could have made developing the law was while discussing the justiciability of the draft agreement. So there's a basic question: can the court nullify an agreement which is not yet there? Yeah? And here I would have expected from the court a more purposive argument. Yeah? It was basically about a timing when the other partner states should be involved in the negotiations. We could have asked, does it make even sense to involve the other partner states? Yeah? Only after the deal with the US has been struck. If that is the case, then after the deal is struck, there's nothing that can be done anymore. So we have to involve them from the very beginning. Then the court could have expounded a little bit on the rationale of the integration. The objective of the regional integration in Africa is to strengthen the negotiating position versus vis-a-vis powerful players, such as the US. The entire idea of Article 37 of the Customs Union Protocol, which the court is quoting, is that we should not negotiate trade deals with other third parties on individual basis, but rather as a bloc, as an EAC, and ideally as a continent. The statement very important with regards to the upcoming US-Africa summit, trade summit, taking place, I think, this week or next week. And to do this, seeking input of all partner states of the EAC is crucial. What the court does is basically dwelling on the wording of Article 37 of the Customs Union Protocol, saying, well, what is a draft agreement? What is an intent? What is a proposed agreement? The court even uses dictionaries to expound on this, on these terms, to basically make a case and to say that, yes, we have jurisdiction over a draft agreement at the stage at which it is now. So more purposive arguments rather than textual arguments would advance the cause of regional integration in East Africa. But this is just only to say that my appetite as an academician is not fully sated. The judgment and the job that the applicants did is very commendable with regard to the second objective, which is to avert the deal, to stop the deal. This is what we need now. And this deal has negative consequences, many negative consequences. So the negative consequence of Kenya having a bilateral trade deal with the US without involving the other partner states and without going through community procedures as prescribed would have serious negative consequences. And I will highlight only two. Now, the negative consequence number one is that it would undermine the customs union. So a trade deal with the US would be compatible with the World Trade Organization, or with GATT, to be compatible with it, would require elimination of tariffs on substantially all the trade between Kenya and the US. But Kenya does not apply its own tariffs, but it applies a common external tariffs, a common external tariff of the East African community. And this common external tariff of the East African community, which a bilateral trade with the US would undermine, is an element of a common trade policy, which, as I said, the Customs Union Protocol envisages. So, if Kenya enters an obligation, for example, to eliminate tariffs on substantially all trade, which would include, for example, elimination of a tariff on plastics, on plastic waste, which is, according to the customs common external tariff, 10% or 25%, depending on plastics and waste to be implemented. Yeah? So the common external tariff says 10%, 25%, and Kenya would say 0, yeah, in the relationship for the plastics coming from the US. What would then happen? Yeah, the common external tariff would not apply. Yeah, and Kenya would have to go to the council and seek an exemption, or a so-called stay of application. Yeah, the stay of application is an exemption for a particular state to deviate from a common external tariff. And ladies and gentlemen, those stays of applications, those exceptions, state-specific exceptions to common external tariff, there are many. Yeah. And if you have too many exceptions from common external tariff, then can we still speak that such tariff exists? The long term. It's being undermined. And without common external tariff, there will be no common external trade policy. So what the applicants did, by filing this case, they made a huge contribution towards the preservation of the integrity of the customs. And my final remark on this, I would like to highlight one particular adverse consequence, negative consequence for the Kenyan economy and Kenyan public policy, which is environment. This trade deal between Kenya and US was an idea which was heavily advocated for by the US plastic industry. That's why I brought the example with duty on plastics, of plastics. So what the US plastic industry wants to do, because the costs of recycling, of disposing plastic waste in the US are high, the US plastic industry wants to export this plastic to Kenya. There are no duties on the plastic waste being imported to Kenya. The US plastic industry can do that. But what are the consequences for us? In Kenya, there is hardly any, because perhaps an exaggeration, but the capacity to recycle plastic waste is very limited. And it would not be for the first time that plastic waste is imported into Kenya. That was the case in 80s and 90s. Plastic waste was imported into Kenya in large quantities and dumped in the desert, in the area which we know today as Marsabit County. And what happened? There has been a health emergency, a surge, a huge surge in cancer cases. There's a case even now. Kituo cha Sheria filed a case against the government, sued the state for compensation for the damage, for the health emergency, for the cancer cases, for the injuries which the people in the Marsabit area incurred because of imported plastic being dumped. Do we want to have it again? Do we want to create another health emergency? Because the US plastic lobby is pushing for the deal. Bearing that in mind, the applicants made a huge contribution to preventing another health emergency and environmental pollution, which would ensue if the deal enters into force. And the US plastic industry may export plastic waste to Kenya. Contrary, by the way, to the African Union Bamako Convention, which bans this, to which, however, Kenya is not a party. That's why the applicant's case is very strong and what they did, very commendable. Thank you very much.
Thank you very much, Professor Mileja. Our moderator, Mr. John Nyanje, has managed to join us, and at this point in time, I would want to hand over to him to make any comments if he wishes to do on Professor Mileja's presentation, then introduce the next presenter. But before then, I would like to mention to you that we are live on Facebook, and we'll be having a plenary session later in the day. So feel free to keep sharing your questions and comments through the chat section. We'll be able to put those together and allocate them accordingly. Welcome, Nyanje, and over to you.
So thank you very much, Mr. Omolo. It's really an honor and a pleasure to be here today. My apologies, I was a bit late. I was headed north towards Turkana. I prepared my journey very well. Unfortunately, nature is one of those things you can't really deal with. And so during the way, I had some few hitch-ups during the travel. And so I'm really, really sorry for this. but also it's really a joy to listen to the discussants on these issues, and my thoughts first when I first read the case is, as Professor Milej says, I think the court takes a lot of shortcuts, which I personally found to be very, very problematic in answering these questions. I think the court would have taken more time to deal with the issues of the objective of the treaty. I think the court should have taken more time to deal with issues of explanations of the roles, including of the Secretary General towards this issue, as Professor Milej says. But also the court needed to have dealt with questions towards the protocol, which they have avoided for so much now, including in this case. And I mean, they partially quote the ENWCA case, which is litigated by Memusi Kanchori, and I found that the court was really trying to be elusive on these issues and not taking the issues head on. But aside from that, I thought the applicant had a good case. The questions were so simple and straightforward. The court just needed to frame itself within these issues. But even more problematic, I find the court unable to answer basic public international law questions like what is a treaty? And for me, this is even more troublesome. The court treats these questions very, very, very lightly. But for now, I want to introduce my the next speaker, and the next speaker is Miss Molly Rwagamba. Miss Molly is a legal and private sector expert with 20 years experience in Rwanda and across the region. She has vast experience and knowledge in corporate and commercial law. She was the CEO of the Private Sector Federation in Rwanda and is currently the managing partner at RR and Associate Advocates. She has served on various boards, including the Capital Markets Authority. She's been a board member of the Student Financing Agency of Rwanda. She's a member of the regional multilateral company based in Kenya called Msingi East Africa. Her main areas of expertise are capital markets, banking and finance, tax advisory, labor and employment law, insurance law, privatization, energy, environmental law, commercial litigation, arbitration, and public policy. Thank you very much, Ms. Molly, for joining us today, and I invite you on stage.
Thank you very much, Nyanje. Good afternoon, everyone. It's interesting to hear the first speakers as they gave their views on this case. And the way I'm going to present it, it will sound like I'm an appellant in this case. And actually, when I look at the time, it was, the ruling was passed. I think it was passed on 2nd of December, 2022, which means that actually the respondents might end up appealing. So as I talk, I'm going to talk about the respondent's case, the strength on their part. When I say the respondent, that is government of Kenya, and also talk about their weaknesses and opportunities, probably some of the things they might look into on appeal. Maybe for those who have just joined us, as I give some bit of my position on the respondent's case, maybe I'll just give just a broad overview so that it can tally within what I'm talking about. So the government of Kenya was in the process of negotiating an FTA. Okay, when we are talking about trade law, there are a lot of jargons, and I really want to explain them because I'll use most of them before while I'm explaining this. If I talk about the Common Market Protocol, just know it's the East African Common Market Protocol. If I talk about the Customs Union, just know that it's the East African Customs Union. If I talk about FTA, Free Trade Area, if I talk about CET, just know it's the common external tariff. And if I talk about the SPS protocol, just know it's the protocol on sanitary and phytosanitary measures, which protocol has not been ratified by some of the countries in the EAC. So as I was just beginning, the government of Kenya was in the process of negotiating an FTA with the United States of America, specifically on wheat, I think on export of wheat. And then also the other thing they had already done, they had already signed the phytosanitary protocol on certification of wheat grain, or you might call it memorandum of understanding on the certification of wheat grain. So there are two issues here that the respondent needed to explain or needed to be able to plead before the East African Court of Justice. Now, as they pleaded, they indicated on the first issue, which is the FTA, they indicated they still had an intent, but the process had not been concluded. And when they said the process hadn't been concluded, that means there was no proposed FTA yet. But again, as the judges were ruling on this issue, and maybe before I get to that issue, the respondent had first indicated the court lacked jurisdiction because it was premature to actually bring this issue to court at that point before anything had been concluded as far as the FTA is concerned. And of course, I think the weakness in that is that evoking the issue of jurisdiction was not the proper thing to do, because court has jurisdiction to hear any EAC related trade matters, but instead they should have indicated that there was no cause of action, because when does the cause of action actually start? The cause of action starts when the issue that you're talking about has been, the issue that you've brought to court has already started taking effect. And when the whole principle of the EAC treaty is, of course, to promote trade, to promote all those objectives that are embedded in the treaty, and you realize that most of them are principles. But now when it comes to the implementation, it's one thing. And also the other element that I wanted to indicate, the treaty or its protocols does not stop partner states from negotiating bilateral trade agreements. What it only stops is negotiating these bilateral agreements without the knowledge of the other partner states. So the issue of communication is very key. And I think that's where the issue culminated from. And when the applicants came to court, they were indicating that actually even when they had, when the respondent had the intent, and which the court, the judges also affirmed, is that even with the intent, you're supposed to communicate. But with intent also, and I think I'll take you, if some of you have the Customs Union Act or protocol, there's an article they kept on referring to, which is Article 37.4.b. And maybe for purposes of understanding the context, I'll read it to you. I'll just read the first part, and yeah. So on Article 37.4, it begins by saying that, just like what I've said, that a partner state may separately conclude or amend a trade agreement with a foreign country, provided that the terms of such an agreement or amendments are not in conflict with the provisions of this protocol. So as long as it does not affect the common external tariff as far as trade is concerned, as long as you're negotiating a trade agreement that is not in contradiction with the treaty, that is not in contradiction with a common external tariff as far as the customs union protocol is concerned, you're free as a partner state to actually negotiate. But there's now a deviation on the main principle. You need to inform the other partner states of the proposed agreement. Now, where I find the weakness that the respondents had is that they were not able to indicate to the judge that this proposed agreement was actually not yet in place. And what was in place was the negotiation. So as you negotiate, I think the judges touched on it, and they said even the negotiation documents, the planning documents, the objectives, but I think that should have been challenged by the appellants, because here what they say where a partner state intends to conclude or amend an agreement as specified in paragraph 4A, which I've just read, that any partner state can conclude an agreement as long as they don't deviate from the treaty and its protocols, especially the common external tariff in this case. The partner state shall send its proposed agreement or amendment by registered mail to the Secretary General, who shall communicate the proposed agreement by registered mail to other parties within a period of 30 days. So what I'm trying to indicate here, when two states or when two people are negotiating, the tools of negotiations cannot be construed to mean an agreement. So until you conclude, and then here I know my land friends will have a debate on it, until you conclude on the key principles on an agreement, but before you append signatures to that agreement, it's still a proposed agreement. And when you look at the principle of when you look at the spirit of the treaty and in terms of communication and this, it is assumed a proposed agreement is what you've actually concluded, the two of you, but before you append any signature, you share it with the partner states to see if they're okay with it. And I'll give an example. Well, I think some of you are familiar with the European Partnership Agreements. When I was still at the Private Sector Federation, before I joined legal practice, I was kind of involved in the negotiations of the EPAs or the EPAs, as some call them. And the EPAs, during the negotiation process, you wouldn't have called that a concluded agreement. But the moment there was a draft EPA, then that was a concluded agreement, which now partner states can sign or not sign. Or approve or not approve. So I brought in this kind of hypothetical reference of the EPAs during the negotiation process. You wouldn't have called that a proposed agreement, but the moment we had an EPA that was not yet signed, that was a proposed agreement. And that's how I can call it. I'll come back to the EPAs later when I'm referring to the SPS. But for now, let me park it there. So what I'm trying to indicate here is that as when there's an intention to negotiate, it's important to, of course, the intent to enter into an FTA. When you look at the spirit of the treaty, whether it's Article 8 of the treaty, you have to communicate. And whether you look at Article 37 that I've just read, Article 37.4 of the Customs Union Protocol, it needs to be communicated. But at what point do you call it a proposed agreement now that needs to be communicated? So I think that was the main issue that the respondent faced, because while you're still exploring, doing market intelligence, gathering your information, that whole negotiation process you can't call it a proposed agreement as the judges try to indicate it in the ruling. And then the other issue that I also want to talk about before I leave this one, the FTA, is this second issue on the phytosanitary protocol on the certification of wheat, which was already concluded. Now, the issue here, was it a trade agreement or was it not? So you'll realize that in these partner states, there are investment treaties or bilateral investment treaties and any other treaties. So we'll agree that they're free trade agreements or FTAs, but they're also trade-related agreements. So those two categories, from a legal perspective, I don't think we can have them as the same agreements, like the court wanted to indicate. And that's for me a weakness that I saw. And if probably the respondents are going to appeal this case, that they might look at a trade-related agreement, because when you look at all investment treaties in every country, you realize that they're almost trade-related. But does that mean that every partner state, before they negotiate a bilateral investment agreement, they should inform all the partner states? I don't think that is how it should be. That is one weakness that I saw on this trade-related agreement, which is this phytosanitary protocol on the certification of wheat. Even though they indicated that we already have this protocol, that's SPS protocol, which, by the way, has not yet been, when you look at the spirit of the Vienna Convention, you can't say that this protocol has started being implemented, because there are several partner states that haven't ratified it. And the Article 151 and 153 indicates how a treaty and its protocol, how this EAC treaty and its protocol are fully implemented. So for them to be fully implemented, they should be, maybe I can read part of that. It says that the partner states shall conclude such protocols as may be necessary in each area of cooperation, which shall spell out the objectives and scope. I just want to indicate where they are supposed to be approved. Article 151(3). Each protocol shall be subject to signature and ratification by the parties thereto. And on 153, it goes further to indicate that it has to be deposited with the Secretary General, who shall transmit certified true copies thereof to all partner states. So this SPS that has not been ratified by all partner states, is it? And also there are a lot of gaps, by the way, in this SPS when you look at it, because it basically talks about harmonization of standards, but till today we still know that each partner state, if something, I'll use an example of Rwanda because I'm in Rwanda. If we have certain things certified in Rwanda, if they go to Tanzania or Kenya, will Tanzania or Kenya recognize that certification? Today, practically, that's not how it's done, meaning that this SPS basically is not operational. So I think it would be unfair to refer to this SPS in terms of awarding to the fact that by Kenya having signed this protocol, the phytosanitary protocol on certification of wheat, that they were contravening the protocol and of course the treaty in itself. So I still find there are a lot of some gaps, whether it's in the treaty, but also in this ruling, which the respondents can actually maybe build on to appeal their case since they haven't appealed it. I think that's what I had. I don't want to go into the details of each issue for determination because we don't seem to have a lot of time. But in a nutshell, that's what I wanted to talk about, the case of the respondent. Back to you, Nyanje.
Thank you very much, Ms. Morley. It's really nice to listen to your thoughts on this. However, I think maybe me and some few others are totally of the opposite view, and which is essentially why this is a very important discussion. And one of the reasons I think, and two issues just quickly before I pass it to Emmanuel, is one, I think states actually don't know what an agreement is or what a proposed agreement is. And I'll give you three examples. One is Qatar versus Bahrain, where you have minutes of meeting that are said to be a treaty or an agreement. Two is what you call the Lusaka Agreement, which is this agreement stopping the influx of Uganda into the Congo, which the court says actually it's a modus operandi, it's not an agreement. Three is the United Nations Agreement on requirement to arbitrate, which was the dispute between the United Nations and the United States of establishing the office of the PLO in the United Nations in the US. So in my view, and this is where I disagree partly with what you say, is I think the court in its right purview should take time to explain what is a proposed agreement, what is an agreement. On that, they fail to clearly explain this issue. I think they would have arrived at that answer just with a very good and a bit of explanation, which is one of my worries, that they don't take time to explain this. And I think always the question of what is a proposed agreement and what is an agreement is a question that rarely states know what actually they have until a court tells them what they actually have. And for me, this was the right platform and view to agree. But secondly is the issue of whether this agreement should be subjected to other members of the treaty of the community before submitting. For me, this is not really a big worry, but on the question of the SPS and establishment of the protocol, I mean, different courts and different tribunals have a different view of this on whether a partially ratified agreement or a protocol would actually apply. A good example would be the 2003 UN Convention on protection of sovereign state assets, which really didn't get a lot of number of signatures. However, for those who took it up, it became applicable. But one of the problems of solving these issues with the EACJ court, in my view, is the court does not have travois. And for those who've gone to the court and asked and researched about this court, you rarely get travois that explain the thinking of the making of these provisions. If the travois were present, most of these questions would not be a big problem to solve. And so I think the court should take a backward look and try to solve some of the problems, like dealing with whether it's really good to rewrite the travois back. I'm sure each state has notes on them. And so this will be an easy way to solve most of these questions and how they will work. So next, I want to invite Mr. Emmanuel Sebijo. Mr. Emmanuel Sebijo is the Dean of Law at the International University of East Africa, Executive Director of the African Institute of Regional Integration Studies, and a partner at International Trade and Investment Cardigan Arbitration. Emmanuel specializes in international law and the law of regional organizations, particularly the EAC, FCFTA, and EU. He's a member of the African coordinator of the International Law Association study on the International Law of Regional Organization and a law report of the East African jurisdiction for the Oxford Law Reports. Mr. Emmanuel is also an executive director of the African Institute of Regional Integrated Studies, a think tank on regional integration processes in Africa, and a director at Center of Law, Economic and Policy on East African Integration, a research center on East African integration. His academic works and journals, including a book on EAC and EU law, have been very useful guides for judges at the court. And so I want to invite you, Mr. Emmanuel, and the floor is now yours.
Thank you, Nyanje. I hope you can hear me. Okay.
You are audible.
So my role in this panel for which I'm very honored to be a part of, and I must thank Kabarak Law School and the East African Law Society for organizing this, but also more specifically to Edmond Shikoli, who at some stage was my classmate, and who is now doing our cohort very well, and very proud by taking the matters that he learned in class to the courtroom and impacting the real world. So thank you for inviting me to comment on this case. My role on this panel is going to be to comment on the submissions of the second respondent, that was the Secretary General of the East African Community, and to identify any weaknesses or technical points regarding that, regarding his response. Now, just in brief, the claim against the second respondent, that was the Secretary General of the East African Community, can be broken down into three. One, that he breached Article 29 of the EAC Treaty, which basically mandates the Secretary General to, in the event that he feels a partner state is breaching or might be about to breach the EAC Treaty, the Secretary General is mandated in those circumstances to write to it with its findings of such a breach. And the treaty then gives the partner state 4 months to respond. And if the Secretary General is not satisfied by the response of the partner state, then he may refer the matter to the Council, that's the Council of Ministers of the East African Community, for resolution. And the Council at that stage might then advise that the Secretary General should take the matter to court, or if they feel they can resolve it politically and diplomatically, then they would inform the Secretary General that they will do so. And at that stage, the Secretary General has fulfilled his mandate under Article 29. Now, the applicants argued that the Attorney General, sorry, I keep I'm harmonizing that with the domestic setting, but let me get into the community setting. So the applicants argued that the Secretary General of the East African Community failed in his obligation to realize a breach and make a finding of that breach and communicate to the partner states of that breach, and then take it forward to the Council. Of course, the respondent argued that he had actually made a finding of the breach and communicated to the partner state through a letter. But really the court found that that letter was insignificant because it was not in the form, this sort of format. I don't suppose that the Secretary General even cited Article 29 in his letter. He simply wrote to the Attorney General of Kenya, informing him that he has read and has come to the understanding through media reports that Kenya is intent on negotiating a trade agreement and has in fact entered a memorandum of understanding already on a trade matter with the US. But he received no response to that letter, and of course he did not follow up. And so the court felt that he had not executed his mandate, because if at all he had written the letter and 4 months later the partner state in question here, that is Kenya, had not responded to the letter, then under Article 29 he should have taken the further steps to forward the matter to the Council, because Article 29 says that if he finds the response from the partner state unsatisfactory, or if the partner state does not respond at all, then the Attorney General, then the Secretary General has a second step to take, which is to take the matter to the Council, which of course he did not. So the court faulted him on that regard and found that he had breached his mandate under Article 29. Second, the Secretary General also has a mandate under Article 71 of the Community Treaty to investigate matters that have relevance to the implementation of the EAC Treaty. It's a very broad obligation and very abstractly drafted, which of course is advantageous to the Secretary General, because he can then pick up on anything that he feels has some level of importance to him and take this up in a matter of investigation, and then link that with his obligation under Article 29 of the treaty to make findings to the partner state and basically take the matter forward to resolution. Once again, the court found that he had breached his mandate under Article 71D to investigate on such matters that might affect the implementation of the EAC Treaty, as Professor Millet stated earlier in his presentation. Without, if Kenya goes ahead to enter a free trade agreement with the US, or even by entering into some sanitary and phytosanitary agreement with the US, it can actually have an impact on the common external tariff of the community, and therefore affect the common external trade policy of the community. So we have to move together as all partner states in dealing with third parties, especially regarding trade. So the court once again found that because of that, and because the Secretary General had failed to investigate that matter and report to the council, then he failed in his duty. Finally, there was this argument against the Secretary General, which perhaps, which perhaps might not have been well canvassed by the court, and also maybe did not come out as clearly in the court's report of the applicant's argument. But the argument that the council is mandated under Article 37 of the East African Community Common Market Protocol to instigate negotiations between the states and come up with a common negotiating position when it comes to external or third-party trade arrangements. The court held that, or at least the applicants argued, that that mandate had not been executed. But because the council cannot be sued directly before the court, there is no standing, no provision of the EAC Treaty gives an individual the standing to directly challenge or to directly bring a reference against the Council of Ministers in the court. What it does is that the treaty provides in Article 4 that the Secretary General of the community will be the overall representative of the entire community. So if one wants to bring a challenge against the decision or action or omission of the East African Legislative Assembly, then it's the Secretary General of the community to be sued. If such an action is against the Council or the Summit or the Secretary General himself, then it is the Secretary General to be sued. So in this regard, the court had an opportunity to kind of expound on this matter, because the Secretary General does not have the mandate under the Common Market Protocol to reach a negotiating position, a common negotiating position with the partner states. That obligation is entirely on the Council. And because the Secretary General is a representative of the Council, the court also held that the community, in a sense, through the omission of the Council of Ministers, had also breached the EAC Treaty by not taking up its mandate to ask the member states, the partner states, to reach a common negotiating position. And as a result, it appears that Kenya decided to go its own route. So on all those three causes of action, the applicants succeeded. And going into the technical part of it all is that, first and foremost, the question must the violation of the treaty be brought to the attention of the Secretary General before his mandate can be invoked under Article 71 and Article 29. And the court said a resounding no. The Secretary General must act like an eagle in the sky, flying over the community, and must keep watch on almost everything that each partner state is doing, so that once he suspects that there's an omission somewhere or some conduct that is an infringement of the treaty, he must immediately take action. He must not wait for someone, for a member of the, for a resident of the community or a partner state of the community to knock on his door and inform him that, look, there's an issue going on right next door. He must keep watch and he must not wait for people to inform him. The court was very straightforward with this. And it gives us a very good way forward and very good guidance, because the previous position of the court in the case of Democratic Party, which is a grand party, the Democratic Party and another versus Secretary General of the East African Community, the judgment was delivered in 2012, and the reference is reference number 6 of 2011. The court had held that, had sort of indicated that in order for the Secretary General's mandate under Article 29 to be invoked, he must be informed of a particular violation somewhere in the community. So he should sit down and fold his hands and wait for people to keep watch of what's going on around the community, and then inform him so that he begins an investigation. That was the position that was established by the court in that case. But thankfully, in this case, we seem to be shifting to a more progressive, a more liberal interpretation of the article. And of course, in the first case, the court did not consider the Secretary General's mandate under Article 71. It simply considered his mandate under Article 29. But this time, thankfully, the court has interpreted Article 29 in line with Article 71, which gives a positive obligation on the Secretary General to investigate and act on matters that may affect the implementation of the treaty, by holding that he does not need to be informed. No complaint has to be filed before him. He must take action immediately there is something. Basically, he should be an ego in the sky and cannot claim that because no one ever brought a complaint on my desk about this, I did not take action. So that was a very helpful finding of the court. The second technical question that arises is that, what if at the time of filing this case by the applicants, the Secretary General had then taken the preemptive steps of actually invoking his mandate under Article 71 and Article 29. He claims that he wrote a letter even before they filed the case. But surely I would feel it was a waste of the community's resources to know that there is a case that has been filed against you, and to sit back relaxing, thinking that, oh, well, I wrote a letter 1 month ago, so everything should be fine. In 10 months' time, we shall be before the court, or in 12 months' time, we shall be before the court, we shall make written and oral submissions, and then carry on. Surely, if you know that there's a cause of action against you, and you know that there are arguments, you've even been filed, you've been served by the reference, and it's on your desk, why would the Secretary General not take preemptive action to basically nullify that cause of action? Because if he had then set about investigating and writing to the community, or to the Attorney General of Kenya, following up on his matter, asking the Attorney General to make his findings under Article 29, and if in that case the Attorney General of Kenya had not made his findings, then 4 months later, which would have been around May or June, if the Secretary General had then tendered the matter to the council, then in a sense, at that level, this case regarding the Secretary General, his cause of action would have been nullified. And the court was very emphatic on this, once again, in the case that I cited earlier, that is Democratic Party of Uganda versus Secretary General and another, where it held that if at all the Secretary General takes preemptive steps immediately, even when the case has been filed, this was the Secretary General's argument, that even when the case has been filed in the court by the applicants, if the Secretary General then takes the steps that is mandated to take under the treaty, then in a sense, it would render nugatory the applicant's cause of action. So as a technical point, and as a question that was part of my mandate on this panel, to advise on what steps or what weaknesses the Secretary General might have pounced upon in the applicant's case, then he might have taken those preemptive actions in order to negate the cause of action against him by the time of filing written submissions or even making of the delivery of the judgment. 3 more issues before I hand over is that the EAC treaty in Article 29, although it mandates the Secretary General to bring up references before, to undertake references or investigations against partner states for breach of the community, it does not provide a periodic framework within which the Secretary General must have basically reviewed a complaint that has been presented before him. Although there is a periodic framework within which the partner state must respond to the Secretary General's findings, the treaty is silent on how long the Secretary General can take with the issue on his desk, saying, or on how long the Secretary General can take with this issue sitting on his desk, saying that I'm still investigating, I'm still investigating, I'm still investigating. Even in the court's judgment, it's stated that the Secretary General claimed that he had tried to follow up, but the court found no evidence of that in his pleadings or in his exhibitions before the court. So it indicates, or it implies, that if the Secretary General had actually followed up on that matter and had brought such evidence before the court, then the court might have found that he had executed his mandate. So in this case, we don't have a periodic framework within which the Secretary General has to act, which I think is a very, as Professor Bile was saying earlier, it was an opportunity for the court to lay out some framework to guide litigants. Otherwise, a future case of this nature might simply be defended by the Secretary General by simply stating that, look, I'm still investigating. This matter is before me. I am carrying out my investigation. So please be patient with me. So I think a periodic framework is very important in this case. Second, fourth, it is also crucial to protect the 4 months period in Article 29.2, within which the relevant partner states are supposed to submit their observations. And essentially, what I'm meaning here is that if the Secretary General writes to the partner states informing them about a potential infringement of the treaty then gives the partner states 4 months within which to respond. And then the treaty says that after that, the Secretary General, if he finds those explanations unsatisfactory, or if there no response at all, then he can take the process forward. Now, there's no protection of that procedure from litigants who might wish to fast track the process and go straight to the court under Article 30 to bring the matter before the court anyway. So it might be advisable that once the Secretary General has taken up an issue and is now investigating it and has written to the partner states, then within that period, no application or no reference regarding that potential breach should be brought before the court. Otherwise, it presents a collision between the mandate and the work of the Secretary General and that of the public litigants. Of course, it might be argued that a number of things may be swept under the carpet by the Secretary General simply saying, I'm investigating and I've already written on this matter to the partner state. So why is this litigant now bringing a case against the partner state? That would be a matter for the policymakers to make, but otherwise it presents a collision, because once the Secretary General comes to court and says, I'm already investigating this matter, and in fact, I've already written to the partner state, then the court might find it useful to stay the application until we hear from the feedback of the Secretary General from that process. Now, how that can be harmonized in order to avoid a conflict and in order to avoid an abuse of that process by partner states and by Secretary Generals can always be discussed in the future. And finally, before I hand over back to you, Nyanja, I got the sense that it is crucial for some provision to be made for a mechanism for the Secretary General of the community to challenge other organs of the community for breaches of EAC law. Now, the treaty simply provides that a citizen or resident of the partner states may challenge the Secretary General of the East African Community for breaches of the treaty by any organ of the treaty. And there's also a provision for the partner states to challenge themselves before the EACJ for breaches of the treaty, and that is in Article 28. But very critically, there is no provision for the Secretary General to challenge either the Council of Ministers or the Summit of the Heads of State or the East African Legislative Assembly for breaches of community law. It is very, very, very important to provide the Secretary General with that mandate, because that is the only way that he can try to ensure the implementation of the treaty obligations against those community organs. We shouldn't only wait for applicants, for citizens and private parties and public litigants to bring those cases, but it should be the Secretary General should have the teeth to bite these other organs, so that it's not just a diplomatic channel and route of telling them, please act, but actually to bring legal proceedings. A case in point is this particular case, because here the Secretary General was sued on the ground that the Council of Ministers had breached its obligation to work with the partner states to reach a common negotiating position for external arrangements. Now, there are so many breaches by the organs in the treaty that end up bringing litigants to a court to challenge the Secretary General. Many of them, including the summit itself, not signing or not ratifying the acts of the East African Legislative Assembly. So many bills of the East African Legislative Assembly are pending before the summit, and the summit has an actual timeline within the treaty, within which they must sign these bills into law. But they meet regularly. Almost every 3 or 4 months these days they're meeting, but they never consider the bills of the East African Legislative Assembly, which are meant to take the integration process forward, including the bills that are meant to bring the monetary union to fruition. So because there are so many breaches of community law by the community organs themselves, I find that it is a necessity for the community treaty to provide a mechanism through which the Secretary General can sue, can challenge these community organs himself. And I know I already said finally, but let me make this final point as a technical point to link the last point that I've just made, is that in the absence of such a mechanism in the treaty itself, there's a technical way within which the Secretary General might be able to sue other organs of the community. That is because Article 4 provides that the Secretary General, that the East African community shall have legal personality in every state and shall be a body corporate in every state. And when you look at the acts of the states that domesticate the EAC treaty, most of them provide that the East African community shall be a body corporate, a legal person within our own nation. Then, to the extent that the East African community is actually a legal person resident in every state, by virtue first of the treaty, but also of the domesticating acts, then it might be argued that that the Secretary General might be able to bring a case against the community as a legal person himself, because Article 30 provides that a legal person or a citizen of the community can bring a challenge against the community for breach of community law, or against any partner state for breach of community law. So could this be a way of the Secretary General bypassing this very convoluted route of Article 29 of bringing findings and waiting for 4 months for comments, then submitting it to the council, which would most likely naturally close it at that stage, because the council doesn't want to recommend another partner state to be taken to the court, because ultimately other partner states might also be victims of the same. So they want to act politically and resolve things politically. But we need lawyers. So we need case law, and we need integration by law. We need judgments of the court to compel partner states to act. They will not compel themselves politically. They've tried that many times and they failed to do that. So the Secretary General might want to harvest some of this technical some of these technical routes provided by the EAC Treaty to actually start bringing challenges against other community organs that have not fulfilled their duties, and also partner states that have not fulfilled their duties in exact breach of in entire breach of the EAC Treaty. Thank you so much. Back to you, Nyaji.
Thank you so much, Emmanuel, for that elaborate view of this issue. I think you capture this issue very well, and my view is this. I was having a discussion with one of my friends who also writes on trade, and he told me, I just think the Secretary General either doesn't know how much power he has, or just doesn't take it seriously. And I think this is the point that the Secretary General should look at this judgment and start thinking, what are the ways in which I can use my office and powers to push for some of these issues and see some of these accomplishments done. Because I think the Secretary General takes a very laid back position and sometimes politically so understandable. But I think the Secretary General needs to see themselves on their wider mandates from the treaty and start taking some of these issues seriously. I mean, it can't be far that the Secretary General spent so much months not knowing what was going on or what was happening. I am just not one of those people who buy this story of how and when he comes to know this. So I want to invite Mr. Dennis Osoro, who is a Senior Regional Integration Officer and an Adjunct Lecturer at Technical University of Kenya. Mr. Osoro has a few comments to make, and I invite you on stage, Mr. Osoro.
Thank you, the moderator, for the opportunity. I'm grateful for this opportunity, and I thank the Kabarak University for convening such a forum in recognition that we need to involve the private sector, the academia, in the policy space, in the multilateral policy space, and especially in capacity building on subjects like this. I would like to go straight into the comments for the sake of time. I will say on my part, I don't know whether this agreement has been signed and ratified. If that is the case, then that is a serious violation of Kenya's commitment under the East African Community. But again, even after being signed and ratified, I don't know whether the matter here was just that certification of SPS. If it was just that certification of SPS, I do not really, from the practice point of view, because I'm an integration expert and I've been involved in so many of these negotiation, exchange of tariff overs in the ACFTA, in the tripartite free trade area, and in the policy space around the East African Community. If it was just that certification, I don't know how it amounts to a violation of the treaty or the protocol, because as Molly said, as Molly submitted, a violation of the protocol occurs when there is an exchange of tariffs, when there is a tariff concession. For example, the East African Community is bound on the hip by the common external tariff. That means the violation of the commitments under the Customs Union Protocol are to extent that a trade agreement has breached the common external tariff. They have gone ahead and made tariff offers that are against the common external tariff. So I think that is the clarification that needs to be made. Another clarification I wanted to make is that partner states are not prohibited from negotiating with third parties. Read Article 37 of the Customs Union Protocol. It says, Article 37 of the Customs Union Protocol 4 says, partner states may separately conclude or amend trade agreements with foreign countries, provided that the terms of such an agreement or amendment are not in conflict with provisions of the protocol. So it's not entirely that the treaty or its protocols entirely prohibit partner states from negotiating agreements. It's to the extent that the process, which involves notification of the Secretary General of the EAC Secretariat before completion of the agreement, and a question arises, which has been a challenge, is defining what a proposal is. What is a proposal? Is it at the beginning of the negotiation? Is it at the conclusion of the negotiation? Because even after completing the agreement, it's still a proposal. You have not implemented, because you complete an agreement, you sign it, you ratify it in Parliament, then you give yourself time to implement. So I want to believe that before you begin implementing the trade agreement, it's still a proposal. So there is a challenge in defining what a proposal, this proposal you want to notify the Secretary General. What proposal is, at what stage is it a proposal? Is it at the point of negotiation? Is it at the conclusion of the, because after you conclude negotiation, that's still a proposal you have not implemented. Then we have a number of challenges with these negotiations in the EAC space. One of the challenges we have is the different levels of economic development. You find that the Republic of Kenya is the only EAC partner state among the 7 partner states that is in low income category. The other partner states are less developed countries. And to the extent that they are less developed countries, they are benefiting from the non-reciprocal WTO provisions, such as the everything but arms and generalized system of preferences, GSP. The implication is that the 6 partner states can access the US market quota-free, tariff-free. Kenya, which has advanced to a low income, that has left the LDC category, cannot access this market. So the challenges that the Republic of Kenya is facing is that all other partner states are accessing those markets. It cannot access those markets, but it's bound by Article 37. So when the Republic of Kenya tries to negotiate an agreement, what other partner states will do is that they will frustrate the process of completion of this agreement. We are told in Article 37 that you have to notify the Secretary General, then give them 3 months for their comments. You find that in most times, the other partners completely ignore the process of participating in the negotiation. So as a matter of urgency and based on national interest, the Republic of Kenya goes ahead and negotiates and completes an agreement because there is no goodwill sometimes from other partner states. That is one challenge that we have established in trade negotiation, especially when it involves third parties. Then the Customs Union Protocol says that the SG should act when they realize that there is a negotiation with a third party that's likely to violate the instruments of the EAC, that is the treaty and its protocols, but it does not give a mechanism through which the Secretary General will obtain this information. I don't know how he will obtain this information because it's not by prompting of another partner state. The Secretary General will act on his volition. So, and another challenge is at what time that will the Secretary General now act? Is it at the point of the proposal as the point of completion of the negotiation. So many gray areas.
Sorry, Dennis. Because of time, I'll ask you to conclude now in 30 seconds.
I will conclude in 30 seconds. We have a case of the Kenya-UK agreement. It takes the same trend where Kenya had an urgency to negotiate. After the Brexit, it was given 3 months to complete a negotiation with the UK, but the other partner states did not show goodwill. So the 3 months could have lapsed and Kenya could have lost the UK market. So it completed the negotiation. A legal opinion, the Secretary General, the EAC directed that a legal opinion be developed on Kenya's violation of the protocol. But even in this legal opinion, they did not define a proposal. So these are some of the challenges that are bound in the space of negotiations of this agreement, and more than definition of the proposal, it's also about when is it a violation? If it has not involved tariff offers, tariff concession, is it still a violation? I submit. Thank you.
Thank you very much, Dennis, for those comments. I'm really glad you made some of these comments. A quick comment from me as I move to the next speakers is this. I've had this argument of Kenya is not an LDC. It can't access the US market. But what about AGOA? Are we not accessing most of these products through AGOA? Was the reason not to try and enter this market that we were not sure whether AGOA would be renewed in 2025? This argument is not based on law, and it's a very moot argument. It's not based on very cogent, strong arguments on this, and that's why I worry. In my view, it was never a very strong argument of, can Kenya access the US market? I mean, it was already doing that with AGOA, and most likely it will continue doing that, and I think that's how it will work.
It would appear that Mr. Nyanji has dropped out of the session. The next presenter should be Professor Mileja, who's coming back to generally discuss the significance of this decision in relation to integration within the EAC, and he'll also expand the discussion to also include integration in Africa. Professor Milej, over to you, and kindly let's do it within the next 5 minutes. Prof. Prof. Milej? Jared, kindly unmute Professor Milej.
Yes, thank you so much.
Thank you.
Thank you very much for unmuting me. In the interest of time, I have many issues that I would like to raise, but I will just focus on two. So number one is the issue of a proposed agreement and intended proposed agreement or intended agreement. And basically what I have observed is that the courts being too formalistic, trying to explain those terms, referring to dictionaries, is making itself vulnerable and exposes itself to the kind of a criticism that Madame Rigamba has very skillfully advanced, saying that, well, the negotiations have not progressed far enough for us to say that we have a proposed agreement. There is an alternative of arguing this issue out, namely is to have to take a more purposive approach. Rather than being involved in sort of a quibble or hair splitting, when do we have a proposed agreement, intended proposal, stuff like that, would be to say that the objective of the Customs Union Protocol, which is clearly spelled out in this document, in this treaty, is to develop a common external policy, common external trade policy. And then we would also observe that, the court has observed that an FTA with the US, concluded with the US, necessarily involves making of tariff concessions that would result in Kenya applying different tariffs to the US, to the imports from the US, than provided for in the common external tariff. The court could have said that it is absolutely mandatory and necessary to involve other partner states at the earliest stage possible in these negotiations. And referring to what the previous speaker has said, this involvement of other partner states and the community organs does not mean that the states must give, other partner states might give a consent to the trade deal struck by Kenya. But, as the court quite aptly puts it, Kenya must benefit from their comments. They must be in a position to start a political process on the community level, discussing the implications of the trade agreement. So that would be my first point. My second point would be about the role of the Secretary General and the role of the individuals. And I think this is this was even mentioned at the very beginning by Honorable Justice Twai when he was referring to the implications of this case. So the role of the Secretary General is, as much as we would wish to her to be the guardian of the treaty, the treaty does not give to the Secretary General a quite crucial instrument, namely to sue a partner state for non-compliance with the treaty. The Secretary General must go through the Council, and the Secretary General may file such a lawsuit only if the Council directs him to do so. And as you know, the Council acts through consensus, and the Council is composed by the government representatives mostly. So in this case, the case demonstrates again that the East African Court of Justice is an intellectual hub, a hub for private sector, for individuals, so that they can step in and they can act as guardians, as promoters of the integration agenda. The court is a very accessible court. You don't have to exhaust domestic remedies, you do not have to have a local standard. So as much as the treaty embraces the ideas of people-centered as democracy, it offers little space for individuals to channel their concerns and their agenda. It is just the court, and to some extent EALA, that allow for that. And then what we have as a result, we have Emily, Christopher, Fleming, Edmund acting as guardians of the integration agenda of the aspiration of the East African community. And this is the main message that this case conveys. We have this David versus Goliath situation, facing itself facing each other in front of the East African Court of Justice. So yesterday it did not work. I mean, Morocco versus France. David versus Goliath. Morocco is not such a David anymore. But it worked in the EACJ. So on the one hand, we had a powerful US plastic industry. I might refer you to the remarks I made previously about the political agenda behind this. So we have this powerful US plastic lobby. And on the other hand, we have Christopher, Emily, Fleming, and Edmund, and others who go to the EACJ and win. And I think this is wonderful. And I would like to stop here.
Nyanje, are you back? Okay, thank you very much, Professor Milej, for those comments on the impact of this in relation to integration within EAC and Africa generally. Allow me to now hand over to Ms. Jemima Muyama from Uganda. Ms. Muyama will be discussing the significance of this decision in the context of the economic partnership agreements. Those are the negotiations between Kenya and a few EAC partnerships with the European Union, which are also related to the matters that were before the court. Ms. Muyama is a Ugandan-born advocate of the High Court of Uganda. She's a trade law expert with an LLM in international economic law and policy from the University of Barcelona. Ms. Muyama is currently employed at a law firm in Uganda, that's J. Biamukama and Company Advocates. And in that position, her roles have been very instrumental in conceptualizing and delivering very high quality seminars, particularly in the areas of international economic law and the role of law in development. Over to you, Ms. Muyama.
Thank you very much. I've been asked, so I'm Jemima Muyama. I've been asked to discuss the significance of the decision that was passed in the context of the discussions on the EU-EAC Economic Partnership Agreement. We all know that on the 16th of October 2014, the East African community at the time involved Burundi, Kenya, Rwanda, Tanzania, and Uganda. They entered into and finalized negotiations for a region-to-region comprehensive economic partnership agreement with the EU. South Sudan and the Democratic Republic of Congo, which joined the EAC in 2016 and 2020 respectively, did not take part in those negotiations, but they are allowed to sign the agreement once it's entered into force. So to fully enter this economic partnership agreement with the EU into force, the EPA has to be ratified by each party, namely the EU, the EAC, and their respective members, according to the ratification procedures. On the side of the EU, the Council of the EU authorized the signing of the provisional agreement as concerns the exclusive competence of the EU. However, the European Parliament is still waiting to approve this agreement because they have not yet received the referral to approve the agreement from the Council. On the side of the EAC, only Kenya and Rwanda have signed this agreement, and Kenya is the only country that has ratified this agreement to date. So Kenya ratified this agreement in September 2016. EAC involves mainly LDCs, as was commented by Dennis earlier on. And so because there are only LDCs involved in the East African community apart from Kenya, they have not had an incentive, an immediate incentive to conclude the economic partnership agreement with the EU. This is because before the economic partnership agreement with the EU, we had the preferential African Caribbean Pacific Partnership Agreement. Now, this agreement had allowed trade with the EU that was free, quota free, and also without barriers. So after the conclusion of this agreement, the other countries that are LDCs were still allowed to enjoy free trade with the EU, basing on the quota, on the pardon me, they could still enjoy free trade with the EU, duty-free and quota-free, because of the WTO agreements that were in place. So the only EAC part, this made them reluctant to conclude the economic partnership agreement with the European Union. This is because them concluding the agreement with the European Union would make them to remove the tariffs they are imposing on their agreements. And yet there is no need to do that if they are still dealing under the quota-free, trade-free regime that they have as LDCs under the WTO. So on the 21st Ordinary Summit in February 2021 of the EAC heads of state authorized Kenya to go ahead, Kenya and any other EAC partner state that wishes to conclude the economic partnership agreement with the EU to go ahead and commence engagements with the EU without needing approval from all other partner states. So this meant that Kenya, which expressed interest to individually access the economic partnership agreement by entering into an interim economic partnership agreement with the EU, was authorized to go ahead and implement this agreement. So all the other EAC partner states have not yet gone ahead to ratify this agreement or even sign it, apart from Rwanda. Now, contrary to the economic partnership agreements, which are negotiated between parties, this made the trade scheme that was implemented between the Kenyan government and the EU, subject to unilateral changes by the EU. This means that in the interim economic partnership agreement that has been signed between the EU and Kenya, the EU was able to make unilateral changes to this agreement because it is not generally governed as it is under the economic partnership agreement with the EAC in general. However, this does not affect the EAC and the common external tariff, because the EU has committed to maintaining the common external tariff while dealing with Kenya in their dealings regarding the interim economic partnership agreement. Therefore, this has allowed Kenya to go ahead and have unilateral discussions with the EU without infringing on their obligations and responsibility under the East African community. So Kenya has also made it possible with the EU for other East African countries to get involved into this agreement by leaving it open for any other partner state that wishes to assent into the negotiations they have made with the EU to join whenever they so wish to join. So the question is, what is the significance of this decision by the court in the context of these discussions? How is this decision significant to the EU-EAC Economic Partnership Agreement? So my view is that provided that we need to learn that the EPA agreement is focused on trade in goods. They do not go into other issues like trade in services, investment, trade, sustainable development, intellectual property, the transparency in public procurement, all these have not been addressed. Under the economic partnership agreement that was negotiated, the countries agreed that after the enforcement of the agreement or the ratification of the economic partnership agreement in all the states, then 5 years after that, they would negotiate these issues. However, Kenya has been put in a place where it has come to be forced to negotiate its own terms with the EU. So this makes it very difficult for it not to engage in other discussions that maybe are not yet covered by the economic partnership agreement without infringing on the economic partnership agreement negotiations that were discussed with all the partner states. I believe this decision is going to put a chilling effect and further delay any negotiations between any of the partner states, but most especially Kenya. And they would all have to consult with each other and wait for other people, wait for other partner states to agree to any decisions they are to make before going ahead to commit to anything towards trade with any third parties outside the country. So this might delay the advancement of the EAC integration in the event that Kenya might reach a point where it's thinking that we have to look out for our trade advancement, and regardless of the common external tariffs and the economic partnership agreement that we have, we will definitely have to negotiate other agreements to foster our own trade development, regardless of the agreements in place. So the question right now would be that, is this decision going to further advance the customs union and the integration of the EAC, or is it going to derogate the advancement of the integration? Will it force Kenya to go ahead and make unilateral decisions to protect themselves and their trade advancement, or will they go ahead to delay whatever they are doing in order for them to foster the integration of the EAC partner states? Because we have seen that as of now, the other EAC partner states are not really motivated to go ahead and sign agreements with with other states outside, because they are still enjoying the liberties that they have under the LDC. That being the case, we have gotten assessments from UNCTAD that other partner states will graduate from their LDC status soon. And if the other partner states continue to develop at the rate at which they are developing, maybe they will in 2 or 3 years' time. Once this happens and they graduate from the low development country status, they might then be forced to also engage with Kenya in negotiating these other agreements, and that will push more integration. However, as it stands right now, I believe this decision, if it is to be enforced and if Kenya is to be stopped from totally even negotiating agreements without bringing them before other partner states to be approved, that will limit trade development and integration on the side of Kenya, since it's not running under the same exact rules as other partner states. Of course.
Hi, Jemima, I will ask you now to conclude in 30 seconds.
Yes, I am actually done, but we have to look, the question is right now, does this decision help to foster the integration, or does it start pushing partner states to look out for themselves individually in order to advance their trade development as countries that are individual out of the EAC? Thank you very much.
Thank you so much, Jemima, for this. And now we've come to the end of this discussion. And so I'll give a few comments as we conclude. One, it's very clear that no one is stopping anyone from the community to negotiate treaties. What all members of the community are being asked to is to live within the objects and purpose of our treaty and our protocols, because this to us is why we created this. And as I was saying before I dropped out, this is not nothing new. The USMCA has a similar provision of this at Article 32.10, which is actually even more detailed than what we have. You saw the US saying that this is a provision to stop Canada and Mexico getting into deals with China that would affect the US in terms of its trading negotiations. Here, we are just trying to protect our interest. In concluding, I want to say this. On the 10th of December in the East African, Professor James Tuogathi, the chair of international law at Loyola, writes this article explaining what African leaders should do at the US-African Summit, which is now ongoing. James Tuogathi highlights 3 issues. One, he says, African leaders must go there and ask for a renewal of their GOA. And this would allow them the tariff-free entry of the market. As we know, it comes to an end in 2025. There is a bipartisan agreement in the United States Congress that the AGOA should be renewed. 2, James says, approach issues as a block. And the way he insists as to why it's important to approach as a block is because he says, look, when you do a free trade area agreement, you open your market to including the big monopolies of the US, like telecommunication, like courier services. So UPS and all these other people will have a free access to the market tariff-free. But 2, you also undermine the Uruguay negotiations on your agricultural products tariffs. Because in essence, the US market requires the opening up of these tariffs on agricultural products. And what Professor Thomas Millet was saying on plastic issues. But 3, he says, let's go and defend the FCFTA at the US-African Summit. And by defending the FCFTA, you are going to ask for trading as a block and not as using Kenya as an example of how the US big monopolies will get an access to the African markets. I think any leader who's going to the US-African Summit should take some time and read what James Tuogathi argues in here. Whether the court was right or wrong, I mean, this remains a big debate and a big issue. And of course, I look forward to seeing whether the appeal will be filed on this matter and what would happen to it. So those are my concluding remarks, and I want to thank you all for joining, and I wish you a nice evening. Thank you very much.
Ilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike, umoja wetu ni nguzo yetu, idumu jumuiya yetu. Uzalendo pia mshikamano viwe msingi wa umoja wetu, na tulinde uhuru na amani, mila zetu na desturi zetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike, umoja wetu ni nguzo yetu, idumu jumuiya yetu. Viwandani na hata mashambani, tufanye kazi sote kwa makini, tujitoe kwa hali na mali, tuijenge jumuiya bora, jumuiya yetu sote.